Okay, that looks really good. So we really appreciate Jim coming and presenting for us. He's done this. We've done this for a number of years, and he always does an amazing job. This is a subject that many people are really concerned about. If we have some challenges that we see, many times it's around conditional uses. And in my own service on a planning commission, I've had some challenges on this as well. So I'm as interested as anybody out there in this subject. And so we'll turn the time over to Jim Wright to talk to us about conditional uses. Jim.
Thanks, Jason. I really appreciate it. That was a very gracious introduction, certainly, and I appreciate the trust inviting us here to talk about conditional uses, and appreciate Brent and Doug and Jason with all their help, and again, the invitation. So it's truly a pleasure to be with you to talk about conditional uses. And as Jason mentioned, this is a topic that we also get a lot of questions about, and is a very timely and hot issue in the land use community, both for local governments as well as for private property owners. So I am very excited to be able to talk about it today with you, and hope that this presentation will give you some helpful information, and will also help start a dialogue in case that's helpful to you, where you feel welcome to call our office, call me, call one of the other attorneys in the office, Brent Bateman, our lead attorney, as well as Jordan Collmore, another attorney there. And we would be happy to walk through any conditional use or other land use questions that you may have. This is a presentation that I have given before here, at least in part, and for any of those of you out there who may have seen this almost 4 years ago when I last did it, I have updated things, and there will be certainly some differences and additions here today. So this is not going to simply be the same presentation that you may have seen before. There have been some new court cases, including a fairly recent case from the Utah Supreme Court, McElhaney versus Moab, as well as this past legislative session. There have been some tweaks to the conditional use statute in LUDMA. And so we'll go ahead and get in this and jump in and see where we go here. But just 1 second, we'll go ahead and, okay, so just click, all right. In terms of the roadmap of what we're going to be talking about today, I'd like to start off with just a basic overview of zoning. And the reason for that, of course, is that conditional uses, it's a subset of zoning law generally. And so I think it would be helpful to understand just some very basics about zoning. Of course, then we will dive into conditional uses more specifically, and hopefully give you some helpful understanding of the law and some tips, and just a broader context to make sure that as you are looking at conditional uses, both in terms of drafting ordinances as well as in terms of applying the ordinances to specific applications, that you get some helpful information to you there. And then we will end with a few case studies. And these are going to be some, there's going to be a couple of additional case studies from what happened last time, in case, again, you were on this presentation almost 4 years ago when I gave it. Of course, as always, we're here to try to be helpful to you. And so if there is a question that you have, I will do my best to answer it. And I have Doug and Brent here as well as Jason. Someone, I won't be able to see the questions, but if someone just lets me know that there is one, I'll do my best to answer it. And of course, again, please take the invitation to call us at the office as well. Our contact information will be on the last slide. You can call us anytime, and we'd be happy to continue that dialogue as well, in case this particular forum is not the most conducive for getting the question that you have answered. So with that, let's do the zoning overview. So just a quick understanding of what zoning is. So it's the regulation of land uses and structures in specific geographic areas within a jurisdiction is sort of a classic definition of zoning. Of course, there's some additional types of zoning at this point, form-based, et cetera, but let's just sort of run with this sort of standard classic definition of zoning. And it's important to understand that zoning has not always been with us. This type of land regulation has not always been with it. It's really been towards the beginning and the turn of the 20th century that zoning started to become a little more prevalent. And this, of course, at the beginning gave rise to some disputes about the legality of zoning. And there were questions as to whether or not it was constitutional or proper for governments to be restricting the use of land and land's development. And so there's a famous case here that many of you may be familiar with, the Village of Euclid versus Ambler Realty Company. And the Supreme Court ended up hearing this case in 1926. And the Village of Euclid is located in Ohio, and they instituted a zoning regime in their community. And this led to Ambler Realtor Company's land having a hard time to do some industrial development. And so they sued over the legality of this zoning regime. The Supreme Court ended up upholding the law, saying it was legal, and their basis was that they found that there was a rational basis in that it was helpful to ensure that nuisances were abated. And they found this was a legitimate use of the police power of the state, and that insofar as it helped to promote the health, safety, and welfare of the population, and as you know, that's a use of the police power. That's the police power. And so again, the court upheld that, and so zoning regimes, as a general rule, are legal in the United States, and they don't violate the Constitution and not otherwise an improper use of local government power. Of course, there's some exceptions on the fringes, and we're not going to get into those here today. That's not our purpose, but just understand from a basic background perspective that zoning, zoning laws are facially, or at least as a general rule, legal. So one thing that we've seen recently here, and that I want to hit on this next point here, is that there's sometimes a misunderstanding as to where development rights come from. Development rights do not come from local ordinances. Development rights exist as a matter of common law. Zoning ordinances and local ordinances restrict the common law right to develop property that property owners have. And so it's important not to confuse the origin of the right to develop property. They do not come from local governments. And so there's a citation there to a Utah case that confirms that. So now that there's just sort of this general background on zoning, let's jump into the more specific provisions of Utah law on zoning. Many of you are undoubtedly familiar with the Land Use Development and Management Act, or LUDMA. There's both a municipal LUDMA as well as a county LUDMA. I've given the citations there for both. For simplicity's sake today in the presentation, I'm going to refer to the municipal LUDMA site, but there is a parallel citation in the county LUDMA as well. But there's already enough citations, and I think to have added both just would have made things even more lawyerly gobbledygook than they already may be. And so that's the reason for just picking one of those for the citations. But this LUDMA grants broad authority to local jurisdictions to pass laws. And there is an express authority to enact zoning ordinances. And of course, as mentioned earlier, conditional uses are a zoning ordinance. They're a subset of a zoning ordinance. And the language specifically says that a local jurisdiction may adopt a land use ordinance that includes conditional uses. So it is permissible to adopt conditional uses. What's important here to note is that you do not have to adopt conditional use ordinances. That is discretionary for the policymaker in each of your respective jurisdictions. So now on to the conditional use basics. So when we talk about a conditional use, here's the definition that is given in Utah law in that Land Use Development and Management Act. It's a conditional use means a land use that, because of its unique characteristics or potential impact on the municipality, surrounding neighbors, or adjacent land uses, may not be compatible in some areas or may be compatible only if certain conditions are required that mitigate or eliminate the detrimental impacts. And so, again, that's the definition. It's the one that's provided in law, and so that's what we need to keep in the back of our minds as we are talking about conditional uses. So as mentioned, again, the inclusion of a conditional use ordinance is optional. A municipality, and of course, as I mentioned previously, county, may adopt a land use ordinance that includes conditional uses that require compliance with standards set forth in an applicable ordinance. Okay, so this is really important right here, that a condition has to be tied to a standard set forth in an applicable ordinance. And this is an area, and we'll certainly talk much more about this, but I just want to introduce this here right now, that we see a lot of problems when jurisdictions forget that any condition that is imposed on a conditional use has to be tied to a standard found in the conditional use ordinance. And so let's talk a little bit more about these applicable standards here. So if we're going to look at a standards continuum to get a little more understanding of what standards are, as you look here on this line, as you go further to the left, there is less discretion. And ultimately, once you've removed discretion, you end up with a requirement, not a standard. By contrast, as you go to the right or towards more discretion, you end up with an impermissibly subjective provision in the law. And so perhaps a couple of examples would be helpful. So say, for example, on the requirements, if there were a provision in the law that said the face of a building has to be covered with 30% red brick, that's a requirement. There is no discretion there. That has to happen. On the flip side, if on going to the right now towards more discretion, the provision in the law said you have to present a development that is pleasing to the eye. Clearly, there's a lot of discretion there, and the reality is there's no way to decide what is pleasing to the eye. That is going to be completely arbitrary and subjective, depending on every individual that may come across and try to answer that. Okay, so there's an example of this continuum in a sort of a concrete, examples. For the conditional uses, you need to be somewhere in the middle. The standard should provide guidance that is not completely arbitrary and subjective. However, there can still be some discretion. That's the whole point of having these standards in the conditional use permit ordinance to begin with. And so the question comes up then, I'm sure, is, well, okay, that's great, Jim, but what is the minimum specificity allowed for standards before a court's going to overrule it? We have some guidance on this question. The Utah Supreme Court, in the case of Thurston v. Cache County, and that's the conditional use case, it's important to note, upheld a decision that allowed a decision maker to ensure the proposed use will not be detrimental to the health, safety, or general welfare of persons residing in the vicinity or injurious to property in the vicinity. And so that health, safety, and welfare standard was found to be minimally compliant in terms of providing guidance to the decision makers, in this case, the land use authority, in a conditional use context. And so there's going to be some standard there. There's going to be something that the conditions have to tie to. You have to be able to tie it back, in the case of that standard, to a health, safety, or welfare matter. And so, that doesn't give carte blanche to decide any condition works. There has to be a connection that is not strained to a health, safety, or welfare consideration. Our view in the office is that is, while legally sufficient, probably too loose. And you're going to want to tighten that down a little bit to help avoid problems that we see. And the reason for that is, as a practical matter, it is very difficult for the land use authority to be given such broad discretion, because what we've seen over and over again is that they tend to take that. And I'm not painting I don't want to paint with too broad of a brush here and suggest that everybody does this. It's just I'm just being frank with you about the calls we get in our office and the issues that we see, with the hope that it can be helpful. This is not meant to be browbeating anybody. But we see certainly more often than would be hoped, that when there is that much discretion, the decision makers forget that they have to tie these conditions to a standard still. And it does not give them complete authority to just come up with various conditions that cannot be tied back to the standards. And of course, we're going to be getting to substantial evidence in the record and that sort of thing in just a minute here as well. But In terms of an ordinance here, we can take a look at this ordinance. It's no longer on the book, so I've deleted references to where it is. But I think this is helpful, at least for getting some idea of what I'm talking about. For example, there in B, use compatibility. Reasonable conditions may be imposed to ensure optimal compatibility with the character of the site, adjacent properties, and existing development. Okay, so that's fairly broad, but then watch how this tightens it down a little bit and gives a little more guidance to the decision makers as they're looking, the land use authority as they're looking to impose any conditions. It talks about that in determining compatibility, the land use authority considers, and it has these list of things. For example, whether access to the site can be achieved without materially degrading the service level on any streets, whether the proposed use would create unusual pedestrian or traffic patterns or volumes that would not be expected with a permitted use in that location, whether utility and public services will be adequate to support the proposed use at normal service levels without adverse impacts on adjacent uses or resources, etc. And so you can see there that these conditions have started out fairly broad, but then given more guidance to the decision maker in terms of going out there and looking for evidence as to whether or not there are going to be detrimental impacts when bounced against or when measured against this more specific standard, each of these standards. And that's a way to help drill down a little bit. So there's still discretion, but it's also narrowed somewhat. And the land use authority can receive some guidance about what type of detrimental impacts are we looking for, and then what conditions may make sense to impose based on these standards and the detrimental impacts that we have perceived or believe are reasonably foreseeable based on the use. Okay, so I mentioned that there has been some tweaks to the conditional use ordinance, conditional use statute here at the state level. This right here is one of them. Previously, it was understood that conditional uses were an administrative decision because of case law. So the legislature had been receiving complaints that this fact was not being understood and followed as it should based on the law. And so they went ahead and stuck it straight in the statute. So now this is in black and white right there in the conditional use statute, that a conditional use permit decision is an administrative decision. Okay? And of course, with the administrative decision comes along certain requirements. We can just briefly review here, and again, this could be the topic of a whole nother presentation, but the difference between a legislative decision and an administrative decision. And the big difference to keep in mind is that a legislative decision is a policy decision made by the policymakers, so the city council or the county council or commission, to enact general policy that applies to typically multiple properties or individuals. And so once the policymaker has made that decision, the administrative decision applies the law to specific circumstances or applications. An administrative decision does not make the law. The administrative decision is not, at that point, it is not a chance to go back and revisit the policy determinations made by the policymaker to re-decide the issue as to whether or not the law should have been passed in the first place, and whether or not, in the case of conditional use permits, we actually want to allow this type of conditional use in the zone. And that's an area that we see over and over again, that there's confusion, and we see that people are trying to sometimes have a second bite at the apple in deciding whether or not they want this type of conditional use in the zone. That decision's been made. Once the legislative decision has been made, there is a presumption that this is a use that we generally want allowed in the zone, but we may need to subject it to certain conditions based on the specifics of any particular application. And it's possible that on what we have seen from practical observation, on more rare occasions, it's not going to be allowed at all. Okay? So there's some examples there of different legislative decisions, administrative decisions, who makes them. They have different standards of review. Legislative decisions are afforded much more discretion than an administrative decision, although there certainly is still discretion at the administrative decision level, and I don't want to misrepresent or have anybody misunderstand that there's no more discretion left at the administrative decision level. There is, but it has to be justified, the decision does, by substantial evidence on the record. Okay? And so depending on the type of decision, and again, we could spend a whole presentation time on this, so I don't want to get too caught up in this, but any administrative decision needs to have that substantial evidence in the record, and we'll get to more of a discussion on substantial evidence in a minute. But, okay. So going back to looking at conditional use permits. So this is, again, going to what I just mentioned about the typical is you're going to be approving conditional use permits, more often than not. The law says that you must approve a conditional use application if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. And it's important, again, not to forget that last part of that statute. It has to be in accordance with applicable standards. So that this is not, again, sort of an ability to go impose whatever conditions feel right at the time. These conditions have to come back, to mitigating these detrimental effects based on applicable standards. Okay. Again, this next bullet point here is another new tweak to the law. There is clarification now in the statute that mitigation does not require the elimination of detrimental effects. That was certainly there before, but there was confusion, and so we're seeing that the legislature wants to lock this down more and more and make sure that there is no misunderstanding about conditional uses. And so that's just one more area where they have made that further clarification.
Hey, Jim, I had a question for clarification.
Yeah.
What is the definition of OTR?
That's on the record. And so that's substantial evidence on the record. And so we'll, when I talk about on the next slide here, the appeals, I think it's the next slide. Yep, next slide. When I talk about the appeals on the next slide, we'll go a little bit into more of a discussion of what substantial evidence is and what it is not. Because that's obviously a very key point in understanding how to properly do a conditional use permit application and process, because it does require substantial evidence in the record. So, when you're evaluating a conditional use permit application, first you have to identify the detrimental effects, if any, and there don't have to be any, but it has to be based on the standards. If there are not detrimental effects based on the standards in the ordinance, then they cannot be considered. Similar to a permitted use. So if there's a permitted use, there's typically going to be some sort of conceivable detrimental effect for a permitted use, but if it doesn't rise to the level of a nuisance or violate some other provision of the ordinance, the permitted use by law is permitted. And so, again, for a conditional use, any condition in order to mitigate these detrimental effects, they have to be tied to these standards. And that's, again, where we see problems when people are not looking for the detrimental effects and not tying conditions back to mitigating detrimental effects based on the standards in the ordinance. I'm probably sounding like a broken record here and going all boring attorney on you. But, again, we see a lot of this, and it's hard to overstate what I've just been repeating in terms of just practical help for people who are in the trenches every day working on these kinds of issues, or who may be policy makers thinking about, what should we have in our ordinance, and how can we craft an ordinance that is going to be most helpful for our community for conditional uses. Okay. So once you have the detrimental effects that are based on these standards, you need to identify reasonable conditions to mitigate these detrimental effects. And then you need to ensure that the conditions relate to the standards in the ordinance and that they are supported by substantial evidence in the record. There needs to be these findings submitted into the record. Okay? So the question undoubtedly is coming up, well, Jim, you're sort of harping on this and making it sound like we can really never deny a conditional use permit. And that's not true. There is a provision right here that allows you to deny a conditional use permit, and that is if the reasonably anticipated detrimental effects of a proposed conditional use cannot be substantially mitigated by the proposal or the imposition of reasonable conditions to achieve compliance with applicable standards, you may deny the application. And so if you're going to deny an application, you need to make sure that you, one, have found out and have a determination of the reasonably anticipated detrimental effects. You have them on the record, and they're supported by substantial evidence. And then that there's not any reasonable condition that can be imposed to mitigate them. If that's the case, you can deny. And if you have followed those steps and you have the substantial evidence in the record, you're going to be upheld on appeal. Okay? Speaking of appeals, so on a conditional use permit application, when the land use authority issues the decision, anybody may make an appeal to the appeal authority of the local jurisdiction. And there's a minimum 10-day window for that appeal, although ordinances may change that depending on the jurisdiction. But once that decision has become final, after the appeal authority there locally has issued a decision, then it goes to district court. And there's a 30-day period under law in which people need to file the appeal to the district court if they're going to file an appeal on an administrative decision. And we have this in the law as well that tells us the standards that a court will look to evaluate whether or not to uphold this decision. And a court will uphold the decision as long as it's not arbitrary, capricious, or illegal. It's like, oh boy, what in the heck does that mean? Okay. So it's illegal if it is based on an incorrect interpretation of a land use regulation or it is otherwise contrary to law. And it's arbitrary and capricious if it is not supported by substantial evidence in the record. And that's, we've harped on that quite a bit here, but let's take a little more look at what is substantial evidence. So here's a case from Utah. This is at least the start of a helpful answer. So substantial evidence is sufficient evidence to convince a reasonable mind of a conclusion. So it's important to note, and courts have given us more information than just this. It's important to note that substantial evidence does not have to be the best evidence. It just has to be sufficient evidence to support a reasonable mind of a conclusion. And so courts are not going to typically weigh evidence anew on appeal as to whether or not the evidence justifying an administrative decision was the best evidence. They're not going to do that. They're going to ask, was the evidence on the record sufficient to convince a reasonable mind of a conclusion? And so it's important here maybe to say what substantial evidence is not. It is not public clamor. Public clamor is just fine when people are coming in to the legislative body when they are considering a policy decision. Neighbors can come in and bring up whatever, terrible facts will happen if the legislative body makes a legislative decision, and they can clamor all day long. Bring out as many pitchforks as you want. That's fine. But once the law has been made, public clamor is no longer legal to use as evidence in the record to support a decision. So, okay, and that certainly, I'm sure many of you have had that experience where people show up to a conditional use permit hearing or meeting, and people stand up and say, if this permitted use, or this conditional use is allowed, the children will die, whatever it is, people come and they say these types of things. And they get really passionate about it, and they obviously feel very strongly about it. Those types of simple emotional appeals, that is not substantial evidence. And that's going to get you in trouble if you make a decision based on those types of statements from the public. What is, or what courts have found to be upheld, and they found to be sufficient substantial evidence, would be sort of testimony, say, from experts on the matter. It would be, reports that may be publicly available from people that have some knowledge area in a particular area. It may be the chance, the deliberations, multiple deliberations and considerations by the decision-making body if it's a particularly contested application. So courts have noted that, well, the land use authority has considered multiple meetings. They've been to multiple meetings and considered various testimony, reports, etc. And the number, sometimes courts have said, of these meetings has been helpful in having a court determine that something met the burden of proof of showing that there is substantial evidence in the record. Of course, a lot of these conditional use permits are uncontested, and I'm also don't want you to misunderstand me and think that you now need to go and have multiple meetings and have expert reports and testimony for every single little uncontested conditional use permit. That's just not going to be necessary. That's going to be the case when there are competing views or people that oppose the application and they're purporting to bring their own evidence, even if it is simply their public clamor. But if it's a simple, little, uncontested conditional use, again, just like with anything else, a much more minimal amount of evidence on the record is going to be sufficient. Okay, let's look at a couple of case studies here. So as I mentioned, the Utah Supreme Court came out with a new conditional use permit case fairly recently, the McElhaney v. Moab case. And what happened in this case is Mr. McElhaney, Mr. and Mrs. McElhaney wanted to have a bed and breakfast in their residence there in Moab. And they were currently, or at the time, they were running a preschool or a daycare out of their home. And they said, you know what, we'll go ahead and end that operation if we can get the permit to do the bed and breakfast. And so the Planning Commission went through, took a look at it, and ended up proposing 4 conditions that they would need to satisfy in order to be granted the conditional use permit. Moab, at the time at least, the land use authority for this type of conditional use was the city council. And so, not surprisingly, the city council is a little more sensitive to political pressure. And so what happened at the hearing is a lot of neighbors came and opposed this conditional use application. And instead of going with the conditions proposed by the Planning Commission, the city council ended up voting down the application 3-1. And each council member spoke as to why they voted the way they did. However, none of them put substantial evidence in the record as to how what the detrimental effects were and how they could not be mitigated by a condition. And so the McElhaney's ended up suing, and the district court overturned the city council's decision. The city appealed, and the Utah Supreme Court on this appeal ended up saying, you know what, there is not sufficient evidence in the record for us to review this decision. And the Supreme Court ended up remanding or sending this case back to the city council to give them a chance to get some substantial evidence in the record to justify the decision, or frankly to perhaps even alter their decision depending on how those deliberations went. And so that's where we are in Utah in terms of what happens in a conditional use permit in case there is not substantial evidence in the record. That's a problem, and it's going to get things sent back. One thing to consider is there may be some jurisdictions thinking that, hey, that's going to cost us some attorney's fees, but I guess we're not going to just straight up lose. Although, that's just the attorney's fees alone, I would hope and would assume would be sufficient to make sure that there's that sufficient evidence in the record. But the problem is that this keeps happening is the pressures that we're seeing and the legislative pressures that will come from stories is that, certainly the law is going to be changed again by the legislature if there's any sort of repeat occurrences where, jurisdictions are not following the law and are thinking they're going to get a second bite at the apple if they don't follow the law. I think it's a real risk, and our office thinks it's a real risk that, for jurisdictions that there's going to be a change in the law. So the takeaway from this is just follow the law the first time. Make sure that there are findings of fact and that, for these conditions and for the detrimental effects, that are in the record, that you have substantial evidence in the record so that these types of decisions can be reviewed by the courts. And if you do that, then you're going to be in pretty good shape, most likely.
Hey, Jim, could I ask
please.
a clarification question here? We had a question.
Yeah.
What counts as a record?
Sure. So my answer to that is going to be, one, it's clear from the law it needs to be written. And so, if you end up transcribing something from recorded meetings, I think that's fine. But you're just going to want to be able to create some sort of written record from the proceedings. If it's a meeting, I think it can be the transcripts and anything that is submitted to the land use authority in the meeting. And if there is no meeting, just whatever information the land use authority used to make a determination. So make sure there's something in writing and that it includes the elements that were used to make the decision. So reports from experts, testimony from experts, any witnesses that speak. And if there are no witnesses, then again, whatever application material came with or whatever materials the staff may have used or come up with or produced to then have the land use authority make a decision on that application. Hopefully that was responsive. And again, as with all these questions, give me a call. Happy to keep the conversation going and whatnot. So, but thank you for that question. If anybody has a joke, feel free to tell Jason as well. We could certainly break up my voice here a little bit. Okay, this next case study is an advisory opinion our office did. And this is where a jurisdiction's approval of a conditional use application was upheld by our opinion. In this case, some property owners applied to have a gun range in a jurisdiction where the gun range itself was a conditional use. The jurisdiction went through lots of hearings, and perhaps is not surprising, there were some neighbors that were very opposed to this, and they felt like it was going to be injurious to the health, safety, and welfare of the neighborhood community. And they brought some evidence as well. It wasn't just public clamor. They brought some evidence even to the land use authority. The land use authority had multiple meetings, considered lots of things. They considered testimony from experts and reports from experts, and ultimately decided that it made sense based on the conditions that they imposed. They felt like they were going to be able to mitigate the detrimental effects from this conditional use, and they approved the conditional use permit. And so the advisory opinion found that there was substantial evidence in the record to support their decision. So in other words, the decision was not arbitrary or capricious because of the substantial evidence. And what was important and what we mentioned in that opinion is that even though there was evidence on the other side, and it wasn't just clamor, there were some reports and similar types of things, the reality is that there was a sufficient amount of evidence on the side supporting the approval of the permit to say that a reasonable mind could conceivably go along with that decision. And once you hit that threshold, again, it's not a question of whether or not it's the best evidence. The court's not going to look at that. The court's going to say, you know what, there's substantial evidence here. Your decision is upheld. Again, as long as it's not illegal. In this case, we also found that it did not violate any other law. So that was a case where the conditional use permit was upheld. And I'm going to talk about another advisory opinion here. But before I do, I'm just going to put in a shameless plug for the advisory opinions on our website. The next slide, which will be the last slide that I will end on, is going to have our website on propertyrights.utah.gov. And if you go there, you can go to view advisory opinions. And there's going to be over 200 opinions that you can go and view based on a variety of land use topics. Think of it as sort of a library of cases that predict how a court would rule in a variety of land use fact patterns. And so it's a resource for you to take a look at. And I would specifically say to go and read, 124, but also especially 191, a more recent opinion. I didn't write the 191, but it's a really great opinion that Jordan in our office wrote that gives a great overview of conditional uses, how to go through and consider them, and then it goes through a whole long list of conditions and just gives a helpful framework for analyzing conditional use permits, and I think would be helpful to anybody who is looking at a real practical application of some of these things that we've been talking about today. And there are certainly other conditional use permits on our website that you might find helpful as well. So in this Reeves Riverton Ranch advisory opinion, a property owner had an approximately 7-acre parcel of land that they wanted to turn into a private park. And that was a conditional use in the zone. And so during the consideration, about 12 to 14 conditions were imposed. And then this advisory opinion goes through and analyzes each one of these conditions. And it ends up only sustaining one condition. And the reason for this is because some of the conditions merely restated requirements that were already in the code elsewhere. And so if it's already a requirement, it's redundant, of course, to have it be a condition as well. The developer is going to have to comply with it. For example, one of them was paving the parking lot. That was already a requirement in code, and so it made no sense to have that as a condition for the conditional use. Others were dismissed because there was no substantial evidence supporting the imposition of the condition as mitigating a detrimental effect based on the standard in the ordinance. In this case, the standard was a health, safety, and welfare standard. And so it was one of those looser standards that we said was minimally sufficient based on the law, but not, in our view, ideal. And so, for example, one of the conditions was that there had to be gates at the parking lot. However, there was nothing in the record that gave any indication as to what that condition would mitigate, what detrimental effect based on the health, safety, and welfare standard would that mitigate. Okay, and there were a few conditions like that that ended up being invalidated in the opinion. However, there was one condition that required two accesses to the parking lot, and having the second access would reroute traffic off of residential streets. And based on the evidence in the record, that had substantial evidence to support that as relating directly to a health, safety, and welfare standard and mitigating a detrimental effect of having the additional traffic on the residential streets. And so the opinion upheld that one condition. So that's, again, just a summary of one of these fact patterns, one of these real-life situations relating to conditional uses. We talked about a couple other ones here, both an advisory opinion as well as the Supreme Court case. And again, feel free to go to the website here that I'll put up now to find more advisory opinions. You have our number there. You can call us. Hopefully this has been helpful in terms of an overview of conditional uses, has given you some ideas of things you should be looking for in your own ordinances, some things you may want to consider as you are drafting the ordinance. And at least one resource you have in case questions come up. Again, if there's maybe just one sort of takeaway, it is if you have conditional uses, you have to be prepared to allow them in the zone because there was a policy decision that they are generally going to be acceptable in that zone with the potential imposition of some conditions to mitigate these detrimental effects based on the standards in the ordinance. If we could summarize maybe this whole last little while in that sentence. But of course, again, feel free to give us a call. I mean, Jason, are there any other questions or jokes that came in?
I haven't got any jokes yet. I'm kind of surprised at that. Folks, if you've got some questions, type those into the chat box or the Q&A box, and we'll get those to Jim right now. Did have a couple of questions. Let's see. As far as maybe just an example of a standard, let's take like noise. There's noise is something that we would mitigate. How do we when we look at that and we put a condition on that, what would be a condition? Would we go right to a certain amount of decibels, or how would that?
Sure. Yeah, absolutely. I mean, you could, and that would be, of course, the least amount of discretion, and that would be. Maybe let's just back up here. So the first thing you'd want to do is say, okay, here's a use, maybe like a dog kennel,
Mm-hmm.
To go along with a luau video, the Land Use Academy of Utah video that our office, that Brent wrote and did. So say there's going to be a dog kennel. Certainly there's going to be the potential for a detrimental impact of noise. And so you're going to want to go and see, okay, are there standards in the ordinance that suggest, and I believe that the standards that I put up previously there had a reference to noise, that to make sure that there would not be noise that would be out of line with permitted uses in the vicinity there. And so if there is some sort of standard that relates to noise saying, hey, we can't have, or we want conditions that are going to mitigate noise that could be a nuisance or that could be out of line with these other permitted uses, then you can go in and say, okay, for our condition, you need evidence, though, that dog kennels are going to create a lot of noise. I'm not saying that you need like a PhD dissertation, but at least get some sort of evidence, whether it's from some other noise study near another kennel or some other, at least some bit of more than just the neighbors saying, that's going to be outrageous, get that evidence, and then you can craft a condition that could be based on a decibel level, based on the evidence that you have as to what would be appropriate based on, again, your standard relating to the noises generated by the other uses in the area. I'm not going to sit here and pretend that this is super easy and that, we're going to be able to, that people are going to always have bright line answers to these questions. And these are great questions, by the way, this type of question. Just make sure that the process is important, though. And if you follow the process of looking at detrimental effects based on standards in an ordinance, and then using evidence to come up with it, which in this case could be, again, absolutely a specific decibel amount that is supported by evidence, or and realistically, that's going to be ultimately the most enforceable, just because it's a bright line. But I'm going to stop short of saying that it's going to have to be a decibel level. I think you could still get something enforceable that would be a little more discretion in that. But.
Okay. Another question came in. Can a city not allow conditional use permits, just have approval from a zoning committee and town council?
A city does not need to have conditional uses in their ordinance. And if they don't have conditional uses in the ordinance, then you default to the permitted and non-permitted uses. So if it's permitted, it's permitted, and whatever requirements are in the ordinance for permitted uses, you need to follow. And if it's not permitted, it's not permitted. If the question is, could you just have like a zoning administrator process the conditional use permit applications? That's fine too. You don't need to have hearings, and frankly, I think, particularly when there are conditional use permit applications that go to the council, which is typically a legislative body acting in an administrative capacity in this case, that's problematic. And so I hope I answered that question.
Yeah.
And if not, again, please follow up. I'd like to be as responsive as I can be. But the short answer is no, you don't need conditional use permits. But if the question was also getting at, hey, can we just have some administrator sort of decide on an ad hoc basis whether we want this or not? The answer to that also is no. You have to follow ordinances. And the policymaker is going to make the zoning ordinances, and then whatever that decision is needs to get followed. That kind of decision can't be delegated to a local administrator.
Okay, but just thinking down the road on this one a little bit. So if we determine, like we said here, that we're not going to have conditional uses, we just have permitted or not permitted. But when we get if it's a permitted use, it's a permitted use.
Correct. And you can have permitted uses with requirements.
Mm-hmm.
You know, when we talked about the continuum there of standards, well, at one end is a requirement. And so if you're afraid about noise, then you have a decibel requirement. If you're afraid about, the aesthetics, you can lock down, again, that example of percentage brick on the face, or whatever it is. You can impose requirements on permitted uses.
Okay.
And so you can drill down to mitigate whatever detrimental effects you're perceiving, and just have there be requirements.
Great, thank you. So we have a follow-up on that, the original question. So you recommend not to have city council validate?
Yes, absolutely, because they're a political body, and this is not a political decision. The political decision is made when the city council or the county council or commission decides to have a certain use as a conditional use. That's the policy decision. That's when you can have public clamor. All the input you want from people with pitchforks or otherwise, great, have at it. That's fine. But once you've made that decision, you then are stuck with the decision you've made. And it is now an administrative decision when an application comes in, and you have to follow the law on evaluating that application, and having a political body that is used to being the legislative decision maker trying to shift gears to be an administrative decision maker. I think, like in the Moab case, you're asking for trouble.
Okay, great response on that one. This one kind of goes along with this. It goes along with that, but it's probably at the code level. Are there uses we must allow in the ordinance?
No. Short answer is no. I mean, that's again a local decision. I will say, though, that at the extreme, you're going to run into a regulatory takings issue if you don't allow any uses.
Okay. So the example,
and I'll even hedge that by saying potentially, but that's a topic for a whole other presentation. But
so the example,
there's no specific use you have to allow.
Okay. I got my mind going on. So this would be maybe like the sexually oriented business or something like that, where there's a constitutional angle on it.
Correct. There is going to be a constitutional angle there, a free speech issue, a First Amendment issue. However, we've seen the Supreme Court case of the Lucas case versus a Carolina Coastal Commission, where there was no permitted use for this owner's property there on the coast of one of the Carolinas. And the Supreme Court said that was a regulatory taking of private property, because nothing that the owner could do with it, really. And so, I mean, if you regulate all or even potentially almost all uses out of the realm of possibility for property owner, you're going to run into that constitutional problem as well, beyond just the First Amendment problem of sexually oriented businesses. And there's other problems, potentially with other federal statutes as well to be aware of course, with the care facilities, group homes, that sort of thing. So,
okay, great. Looks like I've got one more question. For small jurisdictions with limited financial resources, for gathering evidence, what is minimal evidence to be considered valid?
Sure, that's a great question. It's one of these very lawyerly questions that I'm going to do my best to give you a real practical takeaway on. But this is reducing what can be a fairly complicated legal question down to something that I hope is going to be practical. And the answer is it depends. So if it is something that is not controversial, that is fairly straightforward, and you have someone there on staff that can look at this and just submit some little report or some minimal written thing into the record that the land use authority uses, and maybe it's the land use authority, him or herself, that ends up doing this, great. There's something in the record, there's a basis for the decision, that's fine. Like I said, you don't need to go out and necessarily get some sort of expert testimony or reports for every little uncontroversial conditional use application. The flip side is if, like in that gun range incident or in the McElhaney case, where there was certainly much more public involvement and interest in the case, you're going to want to be, in my view, much more careful about what you have in the record. And there, I think you are going to want to potentially have some expert testimony, or at least some reports, some expert reports that would help back the decision. For example, in the gun vault, the gun range question, there were some air quality studies that were consulted by the land use authority to help justify the decision. And so again, where you have a situation where there's a lot more interest and controversy, you're going to be, lawyers like scales, right? So you're going to be moving towards the scale, towards having more and more robust written record of the evidence. So, and you're also going to want to have perhaps more hearings where you can, as the land use authority, review this evidence and deliberate about it before you make a decision. Again, like I said, there's been a couple of cases that have suggested that the number of deliberative hearings by the or meetings by the land use authority was also a factor in the court's determination that there was sufficient substantial evidence in the record to uphold the decision. But again, that's not necessary for something that is, again, going to the other end of the spectrum, uncontroversial and not contested.
So you don't necessarily have to go out and conduct studies if you can use something that is on the public record, studies that have been done, and bring that into the discussion.
Absolutely. So, and even if you're a smaller jurisdiction or something that is more controversial, you don't need to go commission your own studies. For example, in the gun vault, my recollection is that they had a Utah environmental expert with the state of Utah opine, and help give some information on the matter. But you don't need to go commission or hire some consultant to come and give you a report. You can also look at what's already been published. Just have something more than just public clamor or a layperson's uninformed opinion about the matter.
Okay, we need to wrap. I've got a couple more questions here. Are you saying it is inadvisable to have different land use authorities for different conditional uses, zoning administrator, planning commission, or town council?
No, not necessarily. I think it's inadvisable, though, to have the legislative body be a land use authority. That I am saying. Yeah. Many jurisdictions will have a zoning administrator or staff go ahead and look at a certain class of conditional uses, ones that they've defined as probably not uncontroversial. And some jurisdictions prefer to have like a planning commission be the land use authority, for example, for some or all of their conditional use permits. I think, once you start having meetings and going to the public, the trick there is going to become educating the public about what they can and can't submit as evidence, if they want to provide something that's going to be useful for the decision maker, and that's going to be something that if you start having these public hearings and if it becomes more of a planning commission type of level decision, that you're going to want to keep in mind to make sure that there is this effort to educate the public that pitchforks are not helpful. They can be as mad as they want, but this is not the same as when the legislative body is determining whether or not to pass a zoning ordinance. The public has to be educated. It's going to make things a lot easier if the public is educated about what's going to be helpful information provided. But no, ultimately, I'm not saying that you shouldn't have different land use authorities, except for the case of the legislative body. That's not possible in my view.
And the last question is along with that one. The question is, so it's a bad idea to have a town council be the authority that approves or disapproves a CUP application?
Yes. Short answer. I'll give you a short answer.
We'll put an exclamation point on that one and wrap up the presentation for the day. Thanks, folks. Lots of interest in this, lots of great questions, and we really appreciate Jim's time in preparing this and all the expertise that he has there. The Ombudsman's Office information is there, and they're always very accommodating to answer questions and discuss. So please utilize them as a resource. And if you have questions, get with them. They're nice. They'll actually talk to you in a very reasonable way and help you through these things. We've had several questions about the slides and the recording from the presentation. Yes, we are recording the presentation, and we'll put it up on our website. Probably this afternoon or maybe tomorrow. We'll see. I'll send an email out to everybody who has signed up letting you know when that's available. And if Jim is okay with me sending out a copy of the PDF of the
Sure.
slides, I will send it out as well.
Absolutely.
Okay. Thank you so much, everybody. We appreciate it. Have a safe day. Thanks, Jim.
Thank you.